Hello, and thank you for joining us for the SLW Institute webinar, AI Patent Eligibility, Processing the USPTO's New Guidance. We will be recording the webinar today and sending a link to the recording and slides to everyone who has registered. I will also put a link into the chat to where the presentation slides are posted online. If you would like to ask a question, you can enter questions using the Q&A feature in the Zoom menu or in the chat. We will address the questions either during the presentation or at the end, time permitting. And with that, I'll turn things over to our moderator.
Good afternoon, everyone. My name is Nathan Elder. I've been practicing patent law since 2002, and I've had the privilege of working at Schwegman, Lundberg, and Musner for the past 16 years. My practice is focused on the software and computer-related arts, which means most recently a significant portion of my work has centered around machine learning and artificial intelligence. Today, we're fortunate to have an exceptional panel of 4 experts joining us. Each panelist brings extensive experience in handling software and computer-related inventions with a focus on various rapidly evolving high-tech fields, including artificial intelligence. Our webinar today will cover key topics relating to patent eligibility issues around AI inventions, focusing on the USPTO's new guidance and the examples included therein. We'll also discuss stakeholder feedback submitted through the public commenting process. We'll review some relevant PTAB decisions and provide practical drafting and prosecution tips. Today's webinar will be akin to a fireside chat minus the fire. I encourage our panelists to jump in and share your thoughts anytime. We want this to be as dynamic and conversational as it is imperative. So let's get started. Our first question is going to be directed to Hugo Biermann. Hugo, the USPTO's 2024 guidance on patent eligibility reaffirms the existing eligibility framework while highlighting practical applications of AI and introducing 3 new examples. Can you perhaps just walk us through the key aspects of the guidance itself, including any notable statements on the any AI-related claims, and how practitioners might leverage to their advantage the specific wording of the guidance itself?
Yeah. Hi, Nate, and hi, everyone. Thanks for attending. So this is Hugo here. I'm an international patent consultant here at SLW. I'm based in our Silicon Valley office. I've been involved in patent prosecution and preparation for about 12 years. And yeah, similar to Nate, I've been very lucky to work extensively on AI-related patent applications, helping clients to navigate this very rapidly evolving field of technology. So really excited about today's discussion. So yeah, before we jump into specifics on the new guidance, we thought it would be a good idea just to provide some context to frame the rest of the discussion. So in October of 2023, President Biden issued Executive Order 14110. That executive order specifically directed the USPTO to issue additional guidance addressing the intersection of AI and IP, including guidance on patent eligibility. So the guidance we're talking about today was issued in response to that order, and the official name is the 2024 Guidance Update on Patent Subject Matter Eligibility, including on artificial intelligence. So the guidance does a couple of things. Firstly, and importantly, the guidance makes it clear that the PTO's established framework for assessing eligibility continues to apply across all technologies, including AI inventions. So this means that examiners should continue to use the familiar Alice test, the 2-step analysis that has existed for some time now. As most of you on the webinar probably know, the PTO has published a whole host of examination guidance in the past, and these remain relevant. So that's the first important thing, is that the guidance is not intended to really announce any new practice or procedure. It's really intended to be consistent with existing guidance, and we can get into whether it is actually consistent with with existing guidance, but that is at least the intention. The guidance also emphasizes that this doesn't relate to AI inventorship. So the manner in which an invention was developed is not really part of this, or not at all part of this eligibility inquiry. The PTO issued a separate guidance document earlier in 2024 that was called Inventorship Guidance for AI-Assisted Invention. So what we're talking about today is really whether a AI-related technology is eligible for patenting, irrespective of who or what invented it. And that's really a topic for another day. So I don't think we'll have time for that whole discussion today. Then the guidance, while repeating a lot of previous guidance, the guidance then goes on to emphasize some AI specific things. And one of those is the potential for practical applications of AI. So unfortunately, the guidance doesn't perhaps provide as much guidance as we would have liked, but there are some notable statements around practical applications of AI, specifically related to prong 2 of step A of the Alice test. Then finally, the guidance was published together with 3 new examples, and we'll get into those examples in a little more detail. So if we can move to the next slide, Nate. I mentioned some notable statements in the guidance, and here are some of them. So as I just said a few moments ago, unfortunately, the guidance is a little light on, maybe bright line rules around when AI-related inventions are patentable or not. The guidance does say that many claims to AI inventions are eligible as improvements to the functioning of a computer or improvements to a technology or technical field. AI inventions may provide a particular way to achieve a desired outcome when they claim, for example, a specific application of AI to a particular technological field. So the guidance then says, in these situations, the claim is not merely the idea of a solution or outcome, but amounts to more than merely applying a judicial exception. So what it comes down to is the claim then, according to the PTO's own guidance, reflects an improvement in a computer or other technology. So if we can move to the next slide, Nate. So really what that means is that there appears to be a sort of a golden thread running through this guidance. And that is that what the PTO seems to be looking for here is an inventive story. So a story about the invention. What the PTO seems to be looking for here is that the applicant needs to explain the technical problem in the specification, explain how this AI-related invention specifically addresses that problem, and then link it all together in the claims. So one of the important things that we're taking from the guidance is that the PTO seems to be looking for this story of innovation in a patent application. So, and we'll get into this in a lot more detail, but at this stage, I think it suffices to say that when you're preparing a new AI-related patent application, the PTO is looking for a very clear definition of the technical problem and how AI is being used to address that problem. And if you have that in your application from the get-go, you are then armed to respond to a subject matter rejection, like a 101 abstract idea rejection, for example, by referring to what you included in your specification. So by, for example, showing the patent examiner how the claim language ties into a description of an improvement in the specification. And we can get into that in more detail. But Nate, I think I'm going to stop there for now, just in terms of providing an overview of the guidance.
Excellent. Thank you, Hugo. So our next question is related to the examples, and this one's going to go out to Kirt Iverson. So Kirt, as Hugo mentioned, the new guidance includes 3 new examples, some of which are described as patent eligible under 101, while others not. Can you provide an overview of these examples and maybe explain how they highlight the distinctions between eligible and ineligible AI-related claims?
Yes, thank you, Nate. I'm Kirt Iverson. I'm an intellectual property attorney here at Schwegman. I've been here for 15 years. I focus on my specialty is software, and I've been looking closely at the guidance and particularly the new examples to see if there's anything that can help the applicant overcome a one-on-one rejection or even avoid a one-on-one rejection in the first place. There are 3 new examples, as Hugo and Nate mentioned, examples 47, 48, and 49, each of which show some claims that were found to be ineligible and some that were found to be eligible. I want to start with example 47. This relates to anomaly detection. And there are 3 claims given in the examples here. Claim 1 is directed to an ASIC, and it's found to be eligible. The reasoning is that there's a hardware element recited, which is the circuitry in the ASIC itself. But I find this to be very interesting because, as you may know, before the Alice case came out, the way we would often get around a subject matter eligibility rejection, this is prior to 2014, Alice was in 2014. The way we would get around a one-on-one rejection often was to add using a processor to a method claim, for example. And this was sufficient to overcome any kind of subject matter eligibility rejection at that time. Alice, of course, complicated this significantly, and the processor was considered to be a generic component that did not add significantly more to the claim language and therefore was not sufficient to render eligibility. But now with this new guidance, I'm seeing the ASIC as kind of being the same kind of element that we can add to the claims to render them or to have them be considered eligible. For example, if you were to recite some additional operations after reciting an ASIC in your claim, I believe that the entire claim would be considered to be eligible because of the inclusion of the ASIC. Now, the example does refer to some specific elements within the ASIC, but I do not find that that's the reason the claim is found to be eligible, according to the description in the examples that goes with the examples. So I think we can do, in many cases with artificial intelligence applications, especially when they involve training, we can just simply recite an ASIC in the claim. And I think the examiner would have a difficult time asserting that the claim is not eligible for patenting in view of this particular claim 1 example. Moving on to claim 2 of example 47, this is one that is found to be ineligible. And the reasoning behind this is that the claim recites some abstract concepts, a mathematical concept related to the training steps, and a mental process related to the detecting and analyzing steps. And that the additional elements do not integrate the exception into a practical application. Now, the additional elements in the claim related to receiving data and outputting results and using a computer that was trained and applying that, trained with a neural network, and then applying that to implement the claim. So those, what's interesting here is that, to me anyway, is that there was this identification of additional elements, which is an important step in the process that the examiners often ignore. I found that the examiners at the Patent Office, when they're raising a one-on-one rejection, will simply assert that all the elements of your claim are part of the abstract idea, and there are no additional elements that are even to be considered at step 2A. And that's a problem, I think, with the way that the examiners are examining many of these cases. And this, even though this claim 2 was found to be ineligible, it kind of highlights the fact that the examiners are supposed to take this step of identifying additional elements and then determining whether those additional elements are sufficient to render the claim eligible as a practical application. In this case, for claim 2, those additional elements were not enough. In contrast, we go to claim 3 now. Claim 3 was found eligible. And it's because the additional elements that were identified, the ones that go beyond the alleged judicial exception, in this case, the mathematical concepts and the mental processes, were determined to be sufficient. And these steps were detecting source addresses associated with malicious packets in real time, automatically dropping malicious packets in real time, and blocking future traffic from the source address. Now, these are not really steps directly related to the artificial intelligence, and it's more the application of the artificial intelligence. A key reason why these elements were considered to be sufficient to render the claim eligible is that they tied back to improvements that were described in the background materials, in the specification. So the analysis here, finding the additional elements, and then determining whether those additional elements are sufficient to tie or establish that there's a practical application, that the claim is directed to a real technological improvement that's described in the spec. Nate, did you want to throw this out to the panelists for any further discussion of example 47?
Yeah, so actually I just have one question that I can pose to the panel. So in claim 3, it seems like there were additional claim elements that were considered that made the claim patent eligible. And I think those were the last 3 claim elements, which you have summarized here as detecting source addresses, dropping packets, and blocking traffic. So if you take something as simple as blocking traffic, and I know the claim itself was a little bit more than just blocking traffic, I mean, do you have any concerns that an examiner might simply call that last claim element in your claim extra solution activity? And if so, how do you deal with that when you have an examiner that does that? And how do you convince them to read that into the claim as an additional element for 101 purposes? Any thoughts?
Hi, Nate. This is Justin McCarthy. I'm an attorney here at Schwegman for the last 15 years. I'm focusing on software and I've done a lot of AI cases. I think part of what you have to do is, hopefully you've done a good job drafting your spec, and you have that problem solution statement that we've talked about already that kind of identifies that these types of steps are solving a problem and improving the functioning of the computer. And so then you can argue that by adding these steps, you're using, say, the artificial neural network as a practical application. I think these examples are sort of saying that just simply reciting AI isn't enough to confer eligibility. And the key, I think, is, and in this case, comparing claims 2 and 3, is that we're using the output of the neural network in a way that's simply more than just printing out the results, and it's improving some process. And like I said, if you have disclosure in your specification that kind of talks about the benefits of that, I think you'll be in good shape. And
hi, this is Andre Marais here in the San Jose office. Yeah, I just reiterating that as well. Clearly, if you look at the verbiage over there, where it talks about analyzing and outputting data, I think that really doesn't give any practical application. And you juxtapose that against dropping packets and blocking traffic. And Nate, to your question about would that be perhaps argued to be insignificant extra solution activity, I think in this case, clearly not, because this thing, the claim really is directed towards solving that problem of malicious network packets. And I think the actions that you're claiming there, the activities of blocking, etc., are clearly directed to that. Whereas if you just put outputting, if your verbiage around your activities there is just outputting or displaying, it's hard to tie those actions back to the problem being solved, as Hugo pointed out. So I think the main thing there is just to make sure that your activities that you're claiming or the elements you're reciting, the actions there are actual directed to practical applications that solve the problem, and not just a practical application that you're adding in at the end there to that's unrelated or untied to the problem being solved.
Excellent. Any other comments on 47, or shall we move on to example 48? Kirt, do you want to perhaps get going on 48 here?
Yes. One thing I wanted to comment on, Nate, is you mentioned the extra solution activity and when an examiner identifies an element that way. Well, then there's another step in the process. It's step 2B, where the examiner needs to reevaluate all those elements that he considered to be extra solution activity to determine if they might constitute significantly more. So there is another step that the examiner would have to go through to confirm that even those steps that he's identified as extra solution activity are not sufficient. So that's an interesting follow-up to that question. Moving on to example 48. This is an interesting example because finds two different routes for eligibility for a claim for claims related to speech separation technology. The first claim is ineligible because it recites a judicial exception, specifically mathematical concepts, and its additional elements did not integrate the exceptions into a practical application. The additional elements that were not sufficient were receiving mixed speech signal, which was considered to be extra solution activity, and using the neural network to just applying it without any kind of meaningful limitations added to it. And also there was this analysis that the claim as it was written lacked any technological improvement, and that kind of relates to what's described in the spec and how does it relate to the claim language. So this is one example that was not, one claim that was not eligible. Now the next two in this set are considered to be eligible. And each one had different additional elements that were considered sufficient to integrate the judicial exception into a practical application. And they are subsets of the technology of speech separation. The first one, the additional elements that were considered to be sufficient. Nate, I think you can move to the next slide here, where I broke it down. Yeah, here we go. So these are the elements that were considered to be ineligible. Sorry, the considerations for claim 1 to find it ineligible. And Nate, if you could go to the next slide. Right. So claim 2 was eligible because of these additional elements, synthesizing speech waveforms from masked clusters and combining speech waveforms to generate a mixed speech signal, excluding the target source. So the analysis and the determination these additional elements were sufficient, again related to tying it back to the problem and solution that was in the background material or in the specification itself. And there's a particular description about the speech separation technology and how it improves the current technology in the art. Nate, can you move to the next slide? Claim 3 had some other additional elements that focused on a different aspect of speech separation technology. And it was specifically the speech to text part of the technology. So the additional elements that were considered to be sufficient were these steps about converting the mask clusters into separate speech signals, extracting spectral features from a target source, and generating sequence of words to produce a transcript. Again, the reason why these elements were considered to be sufficient related to the description of in the specification about how these particular elements improve the technology of speech to text. So here we have two different routes in the same technology space to achieve that include elements that were sufficient to achieve subject matter eligibility for these claims in the speech separation space. Nate, do you want to open this up to the panelists?
Yeah, sure, absolutely. I don't know if the panelists have anything to add, but I would be curious to know if, based on example 48, if anybody has any specific tips in terms of what they would include in a specification, or perhaps, you know, any new strategies come to mind with respect to, you know, addressing a rejection during prosecution.
Yeah, Nate, this is Hugo. This is really interesting, Kurt, and I think you pointed it out well by saying that claims 2 and 3, both eligible, but really relate to two different subsets of the same technology. So what I'm thinking is, from a strategic perspective, it looks like you don't necessarily have to have a one-to-one mapping here between your problem and solution. You could have a specification, for example, that talks about multiple different ways in which this technology is creating improvements, and you could even have different claim sets, because if you compare claims 2 and 3, I mean, they are fairly different, although they relate to the same field. It's almost like two different subsets. So I'd be interested to hear from the rest of the panel, whether this is something that should be considered from a claim strategy perspective, is whether you could look at having or pursuing, maybe through continuation route, like multiple different scopes based on multiple different improvements that you're talking about in your specification.
Does anyone want to weigh in on that one?
Yeah, I mean, Hugo, I think you're right, and I think when drafting these applications, I think if we just kind of view it as a technical problem and technical solution, I think a single problem to multiple contributing elements to that solution is a very good idea. It'll just give you more flexibility, and and I think options for including, as we have here, multiple claims going slightly different routes. And I think obviously from a patent holder perspective, that's tremendously helpful to have diversity among your independent claims. I mean, you do obviously risk a restriction requirement, but that's always the more options you have, obviously the better. And I also do think even a multiple problem to multiple solution mapping might also be good. The more of that you have in there, the more options you have during prosecution, and it also allows you to consult with your client and the inventors and really figure out commercially in the marketplace which of those problems is being felt and which of the solutions is being effective in addressing that.
Yeah, and I agree with that, Andre. And the other thing that I find interesting about this example is, it almost seems like claim 1, they were trying to kind of claim it broadly enough that it would kind of cover both solutions and both uses. And I just kind of wonder, as a sort of practical thought experiment, whether or not they could have added a few things to claim 1 that would still have maybe covered both use cases and maybe gotten that practical application.
Yeah, I agree, Justin. I think what's very clear from claim 1 and the guidance on claim 1 is that the PTO just really does not find that acceptable where you have this sort of claim that almost stops short of tying it back to the practical application or to the use of the output. They really want us to, I guess, get away from that sort of strategy there.
Yeah, I mean, you're right there. Like this claim 1 just sort of stops at creating these embedding vectors. There's no usage of those embedding vectors.
Yeah.
Kirt, a question back to you. So you kind of mentioned that the specification had a lot of description about the problem and solution. I mean, in your view, if the specification had been a little less in depth on that, and we were dealing with the same claims, could you see like exactly the same claims getting an ineligibility decision if the specification wasn't as thorough in its description of the technical problem and how this was a solution?
Yes, that's what it all comes down to, is what is the technical problem and solution described in the spec, and does it tie to the claim language? If, let's say, the additional elements identified in claim 1 had a more thorough description in the specification, identifying why those elements are sufficient, or sorry, not why they're sufficient, but explaining the technical problem and the solution in terms of those elements, I think that would have possibly rendered those additional elements of claim 1 sufficient for eligibility. So it's really kind of how the applicant writes and drafts the specification and how they describe the problem that determines, I think, whether something is sufficient, whether an additional element is sufficient.
So I guess a practice tip there would really be to be thinking about that very deeply and what you're going to be arguing when you draft the claims, and backing into the specification there to make sure that you've got very detailed descriptions around that in the spec.
Excellent. I think we have one more example that you are going to discuss, Kirt, example number 49.
Yes. Example 49 is a fibrosis treatment. So it's kind of outside of the software space, you would think. It deals with treatment for, an eye treatment for patients that are suffering from a certain condition. Claim 1 is considered to be ineligible because it recites multiple judicial exceptions. Mental process, mathematical concepts, and laws of nature are all considered to be related to these claim elements. But what's interesting, I think, and very fascinating if you were to take this into the software space, kind of the analysis here, is that claim 2 is considered to be eligible. And all it does is specifically identify that the that the eye drops are of a particular compound that's described in the specification. It's called compound X. So the treatment is specifically identified in claim 2, whereas it was more generically recited in claim 1. And adding this single dependent claim, very, very easy dependent claim where it says wherein the treatment is specifically compound X eye drops, that was sufficient to take this claim from ineligible to eligible. And I think that this, even though this is a fibrosis treatment and it's not directly related to software, I think we can take something from this. I really think that if you narrow the field of the invention to a specific, subset of individuals that are affected, or let's say subset of clients or subset of servers, or however you are identifying a certain generic group in your independent claim, a simple dependent claim like this could arguably render the claim eligible, even in the software space, I think. Although, an examiner might take a different view and say this is not applicable to software, but I do think it's very interesting that just narrowing the technical field, the focus of the claim, can possibly make the claim eligible for patenting.
Yeah, so Kirt, this is really interesting. I agree. So would this be, if we want to tie this or link this to the software space, would this be similar to, something like instead of just claiming very generically what you're doing with some sort of output, tying it to a very specific field, like using the output to separate a speech signal or something, just to go back to one of the earlier examples, would that be sort of the argument that one would go for here? And
I would,
yeah.
Yep. Yeah, I think so. Anything that narrows the output, or not even the output, it's the target of the claim. Like what is the claim focused on changing, or and then narrowing it in some way with a dependent claim. I feel like you can draw an analogy to this, even in the software space. And I wonder what the examiners will say when we try to argue that we're narrowing the application to a specific group, even in the software space.
Okay, so we've discussed all three of the examples, and I before we move on to discussing the public feedback, I just want to ask the panelists sort of what their feedback is generally on the guidance, and specifically, given that this is supposed to be sort of AI specific guidance, do you feel like this is maybe just the patent office signaling to patent examiners that AI should be given the benefit of the doubt in terms of patent eligibility? Or do you see something specific in the guidance that you take away in terms of new strategies, either for drafting or prosecution? Or is this really just kind of reiterating what we already know? I mean, I know it says that it's confirming or reaffirming the framework, but what are your thoughts on that?
Yeah, for me, I think it's kind of, you look at it and you're simply sort of using AI to do something. There's no, it's not really specific. These examples, I don't think, are really specific to, sort of the structure of the model or any unique ways of training the model. They're really confined to just sort of use cases of the model. And I think what the PTO is saying here is that the use case of the model, just using the model to do something, is going to be sort of looked at under the traditional framework. that it's basically, you know, just I mean, they pretty much called it just a way to generically implement something on a computer. And so I think, you know, the practical application in those examples anyway is what you have to kind of lean on. Now for improvements to the model itself, for example, or for, you know, improvements to training and other things, I still think there's a lot of uncertainty there.
Yeah, Nathan, at a high level, I think, you know, Hugo mentioned at the beginning that this really highlights the potential for practical application of AI. And I think what the PTO might be, you know, signaling through this guidance is to the examiners and to applicants is, you know, really focus on that. We probably won't have time to do to review in any detail, but we've got some slides at the end here that will be circulated on PTAB decisions and particularly reversals. And you'll see the majority of the reversals for AI and broadly across, you know, software is really on this practical application, you know, step 2A prong 2, you know, integration into a practical application. So I think that's kind of what they're signaling. If you look at those PTAB decisions, if you get into the appeals and you're having to argue step 2B, where, you know, significantly more, you might be grasping at straws. It doesn't look there's very little reversal based on that, but we do see a lot of reversals based on this practical application. So I think, to me, that's the big takeaway here.
Yeah, I would agree, Andre. And I think in particular, I think they might be signaling that AI is included in the category of other technology, because a lot of AI is software based and is not going to directly impact the functioning of the physical hardware. Now, that's not true of all AI, of course. NVIDIA reported their stock earnings yesterday, or their earnings, I should say. Obviously, that's physical hardware, but a lot of AI is software. And so my thinking is too that the patent office is kind of signaling that AI should, when the claim is drafted properly, fall under other technology or other technical field. Justin, I know that the patent office has received a lot of feedback. Do you want to perhaps walk us through some of the key themes from the feedback and share your thoughts on their implications for practitioners and inventors?
Sure. You could go to the next slide. So, you know, just kind of a summary. A lot of the feedback focused sort of on the use of mental processes. Some of the commentators challenged the USPTO's finding that many of the steps in the examples were mere mental processes. They sort of focused on this idea that, you know, the PTO had already said that, you know, in order to be a mental process, it has to be practically performed in the human mind. Some of the folks just said, hey, listen, you know, AI and machine learning can't be practically performed by a human. You know, IBM, in fact, kind of went a step further and said that it shouldn't be held as a mental process unless it achieves the limitation's purpose in real circumstances. And another commenter kind of pointed out that it's not clear why some elements were labeled as mental processes where others were not. And they kind of focused on some of these, you know, dropping packets and this, you know, the blocking packets, and kind of said, well, you could do that as a human being could do that, right? You can go on your router and type in some packets and some source IP addresses and get those blocked. So they were kind of concerned about that. And one thing I want to point out is, you know, as part of the guidance, the PTO sort of separated, is at least with Claim 47, they sort of separated the analyzing with the artificial neural network. And I think some of the guidance or some of the comments were a little concerned that sort of the analysis divorced the technical implementation from its function. And when the claim recites specific technical means like a trained neural network for performing the analysis, that the one-on-one analysis shouldn't strip away those technical elements to just reduce it to the abstract concept of, say, anomaly detection or analyzing, because that sort of presupposes the result. And to give you kind of an idea of what we're talking about, Nick, can you go to the next slide? I was a little curious here. Nate, can you hit the next slide?
Yep. I do. There we go.
So I was curious just how long some of these artificial neural network operations would take you to do in your head. And so I asked GPT-4, I asked ChatGPT, what's an estimate for the number of calculations that are run for a single word query on GPT-4? Now, obviously, this is ChatGPT, so it's not, I mean, I wouldn't hold it up as, the pinnacle of accuracy. But its response is that for a single word or token query, it's likely that to be something, between 10 and 50 billion floating point operations. And then I asked it, to make some reasonable estimates for human calculation speed. How long would it take a human to perform those same calculations? You can go to the next slide, Nate. And it's kind of funny. For simplicity, let's assume that the human can perform 1,000 basic operations per second. I don't know about you guys, but that's way faster than I can do that. But even at 1,000 operations per second, it would take roughly 9 to 10 months to perform, to perform all those calculations. If you go to the next slide, Nate. I followed up. Let's assume a human can only do one operation every 3 seconds. So for one token, just one input token to go through the ChatGPT or GPT-4 model would take about 2,383 years. So that's incredibly fast. And so I think the PTO has a little bit to sort of break that claim apart. I think is a little silly, but and I think some of the commentators kind of pointed that out. Nate, can you go on the next slide? Sort of the next theme is the idea of their use of sort of mathematical formulas. So some of the commentators were concerned over the labeling of the recitations as mere mathematical formulas. I think they rightly pointed out that there's some conflicts between some of the other examples where the PTO said that, listen, if it's not explicitly recited, like a mathematical formula isn't explicitly recited in the claims, then it's not it doesn't recite a mathematical formula. And here they sort of read between the lines with the backpropagation and the other algorithm. So, and other sort of comments were concerned with this tension because if you're not specific enough, the PTO will label it as a mental process. But if you're too specific, then it'll be labeled as this mathematical algorithm. So some of these commentators were concerned about how do you kind of strike that right balance. One commentator just flat out rejected the idea that a mathematical process was sort of per se ineligible. As at least one commentator sort of pointed out that these examples encouraged kind of an illogical result, that by broadening the claims, by removing the backpropagation and gradient descent recitations, that the claim might be eligible. And it would actually have a greater preemptive effect. And another commentator just kind of said that, look, the office is taking a dim and improper view towards AI ML innovations as nothing more than math. Can go next slide, Nate. I think one of the more interesting comments was that there's this sort of double standard existing between hardware-based and software-based neural networks. I mean, what makes the ASIC implementation of the AI model any different than, say, running that on a general purpose processor? Some commentators pointed out that there are some inconsistencies between example 39, a previous example, and example 47. So in example 39, there was 2 steps. It was basically training a neural network. I think it was facial detection. It's training a neural network, and then using real world examples basically to refine the neural network and to retrain the neural network. And the PTO found that not only was there no math involved, but that the claim was eligible. And so there's a pretty big inconsistency, I think, that the PTO really needs to address that. Many of the commentators argued for legislative fixes such as PARA, Patent Eligibility Restoration Act. And then again, as I stated before, some commentators indicated that the examples really didn't address what specific improvements in AI would confer eligibility. So the elements in these examples that overcome the 101 issues were not AI themselves, but other activity like dropping packets and things like that.
Excellent. Thank you, Justin. We've got about 13 or 15 minutes left. And I know, Andre, you had perhaps a couple of PTAB decisions that you wanted to share that are potentially relevant to AI.
Yeah, no, thanks, Nate. I do. Maybe we could go to the next slide. Hugo, did you want to? I think it's kind of interesting because this segues back into some of the commentary on the guidance. But this is just one decision. Most of the decisions we've looked at are the more recent ones, 2024, 2023. But this is one from 2019. Hugo, did you want to quickly just walk through this? And I think focusing on the ordered combination, and then I've just got some. Just a quick comment on that as well.
Yeah, I mean, very briefly, I think this is just one example of many of a case that sort of aligns with the guidance examples, really, in the sense that the way to look at claims is really not to look only at the specific steps that are being claimed, but rather to look at the overall claim and the combination. So this particular case, Sean Henry, the PTAB found that if you look at the individual steps that are being claimed, they might seem very, mathematical or abstract, but if you look at them as an ordered combination, then it goes beyond something that is an abstract idea, and it's found to be patentable. So that really ties in with the examples that Kirt discussed. So, for example, if you look at example 48. In both claims 2 and 3 that are said to be eligible, you have some of the steps that are said to be abstract ideas, but then there are additional limitations. And the PTO says when you add these additional limitations and you look at all of the steps as an ordered combination, it could integrate it into a practical application. So I don't know, it might be something that examiners are not doing enough. I'd be interested to hear the thoughts of the rest of the panel, but examiners might not be looking at these additional limitations enough and just making a blanket statement by saying that the entire claim relates to an abstract idea. Yeah, Andre, that's really all I wanted to point out here.
Yeah, and I think actually the AIPLA on comments submitted on the guidance also did critique, noting that, well, basically critique the guidance's handling of ordered combinations, and it particularly noted that some of the analysis failed to recognize that a combination of work, and that being well understood. The R is routine and conventional, so the acronym there is work, WURC. Activity elements may amount to an inventive concept when the analysis is applied to the claim as a whole. So that's one critique that the AIPLA submitted with respect to the guidance and the examples over there. So, I mean, if you look at the I think the Alice Mayo framework really does, when it asks what else is in the claims, it really does ask, it requires kind of a consideration of the elements separately and then in an ordered combination, and then really whether the ordered combination improves the functionality or gives you an inventive step. So I think that's one thing to maybe the takeaway there is that this ordered combination was maybe not as well addressed as it could have been in the guidance. Nate, do you want to go to the next slide? Yeah, so basically what we also did here is we just looked at PTAB reversals in the last 2 years, and of those decisions, I mean there may be more, but I think we kind of found 4 AI related in 2024 and 3 AI related reversals in 2023. So I think that it's interesting here to compare what the PTAB is doing vis-a-vis the guidance that came out from the PTO. And I think there's a consistency there that you'll see that I mentioned this earlier as well. Most cases reversed, most of these PTAB reversals of the examiner were reversed based on step 2A prong 2, and that's really this integration into a practical application. Across all of those decisions, I've listed over there some technological improvements that were found in these decisions. Training optimization, specialized data structure, process control, manufacturing equipment and optimization, clearly good examples of practical applications. The board also, I think, looking across all of those decisions, really found a lot of cases that were eligible, as we talked about before, solving computer-specific problems, specific implementations rather than abstract results. And interestingly enough, also contains steps that were too complex for mental processes, which is interesting because that goes back to step 2A prong 1, the mental process. Maybe would you go to the next slide? So these are the 2024 decisions, and I'm not going to dive deeply into these, but we've got some, I've got one slide on each of these later on. But I think there are 2 decisions that people might find interesting, ex parte DAS and ex parte NIR that I've got over there. And those were actually cases where the PTAB reversed the examiner on mental process. In ex parte DAS, it really was saying that the training of neural networks cannot be practically performed in the human mind. And as you'll see there, the claim is really focused on training neural networks rather than the abstract idea. Similarly, in ex parte NIR, there was that was initially rejected by the examiner as a mental process, and interestingly, the PTAB here said that the calculations that were claimed, the precision that they were claimed, that could not be performed by a human mind, and that's when they stopped their analysis. They didn't go to the other prongs. They just said, "Oh, this is, this is eligible." We then get into 2 decisions there where it's practical application through this ordered combination of trained models in the next decision. Anyway, again, not going to spend too much time. And then Nate, you want to go to the next slide? Here's some decisions from 2023, or decision reversals. And again, you'll see there it's really integration into practical application, which was the basis, for that. And yeah, I think the subsequent slides that we've got over here do deal. We've got a slide on each of these cases, so I think we'll circulate these slides after the webinar, and feel free to look at those. But I think they provide also maybe some additional guidance beyond the examples that the guidance has already provided. I mean, I don't think any of these are precedential, but nonetheless, at least you can kind of see where the PTAB's going and how they're considering things, particularly on these decision reversals. Nate, I don't know what the next slide. Do you want to jump to that one? Yeah, these were just where we talked about integrations into practical application from the above decisions. This slide just gives some examples of those practical applications from that might be helpful to people to consider. Particularly, I think we often talked about security and data processing. Actually, email fraud detection. It applied AI to analyzing the keyboard distance, doing this keyboard analysis distance, and that was deemed to be because it had a security function, was deemed to sufficiently integrated into a practical application. Okay, and then I think Nate, after that, I think we get into the slides for each one. Yeah, so I'm not going to walk through those. We kind of looked at it, but I did want to leave some time for questions.
Yeah, we have about 5 minutes left. I guess we can take questions or.
Yeah, or I think Hugo, did you want to? I think the other thing Chris also wanted to take a brief look at is that EPO, the European situation as well, and I think it might be interesting to talk about that.
Yeah, we could just touch on this really quickly. I know there are a few questions. So a query that we also get from clients with increasing frequency is, what do we need to include in our AI-related patent application to ensure that we've got enough there for, enablement and written description and that kind of thing. And there's a very interesting case recently before the EPO Board of Appeal. So this is not directly related to eligibility. So it relates more to enablement, but it's still important because what we're seeing through today's discussion is this whole story of innovation that you need to tell. And in this case, what the EPO Board of Appeal said is that the specific patent in question did not provide enough information in the specification to enable a skilled person to perform the invention. So in that particular, and what you would need to provide would obviously depend on the invention. So it would be assessed on a case-by-case basis. But in this case, the board was pretty scathing in the sense that it basically said that the applicant only disclosed a neural network, but with no details on the architecture of the model, no definition of the input and output variables, no description of the training process really, and it didn't even really provide one working example. So in that case, the EPO really said that it would require a lot of experimentation and undue effort from a skilled person to actually be able to reproduce this invention, if at all. So I think a takeaway for me from this case is, as part of telling this innovation story in your specification, you need to make sure that you provide enough technical detail on all the important aspects of the invention. So for enablement purposes, but also to provide fallback positions. So Justin and Andre, you talked about mental process. So for example, one of the things that I'm thinking is, if an examiner is rejecting your claim based on mental process, if you have enough technical detail in your specification describing, for example, that your model has millions of parameters, how many epochs of training you would need to do to train this model, you're really providing yourself with some nice fallback positions to respond to those types of rejections, to show to an examiner that, look, this is not a mental process. This is not something that can practically be performed in the human mind. So yeah, thanks, Andre. That's a really interesting discussion, and we obviously included in the slides for folks who are interested in doing some further reading.
Yeah, I think we are just about out of time. And I would say that the slides, I believe, have been posted to our website, slwip.com. And so unless the panelists have any final comments, I think we're going to call it a day. Anyone have any final thoughts?
I think
Okay.
I think we're good. I mean, I see there's one question quickly. Maybe we can sneak that in. Is like, does adding the inventive story add to the application risk characterizing the invention unduly? I think over there, as long as you kind of couch the inventive story in, and not make it the exclusive story, and use kind of permissive language around that, I think you can mitigate that risk, hopefully. But yeah, it's, as you said, it's kind of, it can be a double-edged sword.
Yeah.
Yeah.
I think it's a balancing act, right? You need to tell enough of a story to get around 101, but not to characterize it. So
yeah, there's also a question around when examiners seem to be flip-flopping between 103 and 101. And I think we've discussed this offline. I don't know if we have enough time, but it is a problem. And I think, Nate, one of the things that we see is examiners almost use step 2B as as something that's akin to 103, which can be really problematic, and it just highlights the uncertainty that we have at the moment.
Yeah, when I have a 103 and a 101 rejection, it seems like I guess the advice I give my client really depends on the strength of the 103. A lot of times I feel like examiners have an objection to allowing the claim, and they can't make a good prior art rejection, and they rely on 101. So I guess, yeah, but
Yeah.
it's very fact specific, obviously.
Yeah, I mean, I think in my experience, the best thing is to kind of feel the examiner out with an interview and try to see, because it could be just that they don't want to allow the claim, or maybe their supervisor doesn't like it, or what have you. And, sometimes in that instance, the only thing you can do is appeal.
Yeah.
I see there's a question about the example 1, claim 3, and about the examiner maybe requiring these additional steps. The examples are sort of showing what the examiner might require. So if this application had gone through prosecution, I believe the examiner could have or may have required that those elements that were found to render the claim eligible, that claim 3, would be added during prosecution. So I think that's kind of the direction that the USPTO is going, is saying we need to add those steps, like detecting the source address and automatically dropping the malicious packets in real time.
So there was one question: will claims become more obvious as AI becomes more advanced? And I think as AI becomes more advanced, some of these things will be harder under 101. I think the PTO likes to use the routine and conventional label. And I think that was another thing that some of the commentators said, is that, what is routine and conventional, it really shouldn't be used as a guideline for whether or not something's patent eligible, because that should be sort of time invariant. But I do believe, yeah, as AI becomes more popular, it's going to get more challenging.
Yeah, and I think it just highlights what we've been saying around not describing your AI components as black boxes. Because I think once you start doing that, you're almost helping the examiner to reject it, to say, well, this is routine and conventional, because look at the way that you've described it in the specification. And we're seeing that, for example, with things like language models, whereas 2 years ago you would think talking about a language model in a patent application is very novel and not something a lot of people have seen before. But now we're seeing examiners saying, a language model is super well known and routine and conventional, and you just mention it in passing in your application. So it's not really something that I as the examiner see as an additional element that's going beyond the abstract idea. So yeah, for sure, it's a problem.
Yeah, and think of claim 1. The very first claim in the examples is just an ASIC, and that is, I guess, it's not novel, and it's obvious, I guess, but it's considered to be eligible. So you can think of it that way.
So Hugo, with respect to language models, for the longest time, we've included a figure of a computer, for various legal reasons. You think it's helpful to include some figure of a language model when you're potentially going to be relying on that for novelty, even though maybe, it's just your claim involves using a language model?
That's a good question, Nate. And we've been discussing this internally, and it obviously depends on what the invention is. So if your invention is a new type of language model, then of course you're going to focus a lot on the architecture of the new model. But even if you're just using a language model, so if it's more of a sort of a client layer type invention, we think it would still be pretty useful to have a drawing that shows where within the broader architecture that language model fits in. I mean, Andre and I actually discussed this recently offline, is that it might really be helpful, and we've started doing that, including in your figures a language model, and then depending on the type of invention, showing that language model within the broader architecture.
Yeah, agreed. I think on some of these, it's helpful to have data that talks about, you know, what the training data is, how the training data is labeled, if it is labeled, what the training algorithms are, what the models are, what the sort of the names of the models, you know, in addition to everything else, because that's just great fallback. But you have to be a little careful because, you know, just inserting some boilerplate could get you into some trouble because, for example, if you talk about a model that couldn't actually perform, you know, sort of what you're saying it could perform, you know, you can get into some trouble there. So you have to be careful and kind of know what these technologies are to be able to use them.
All right, well, we're a little past time. I'd like to just thank everybody for attending. And again, the slides are posted to the website. And I think if anyone has any follow-up questions, I'm quite certain that any one of our panelists would be happy to have a discussion. So thank you again for attending.
Thanks, Nate. Thanks for moderating. Thanks, everyone.
Thanks, everyone.